Hello, everyone, and welcome to Black Swans and Contract Review Navigating the Unthinkable. This webinar is sponsored and presented by Superlegal. My name is Tangwen, AWCI's Education Program Manager. At this time, I'd like to introduce our presenter, Christopher Lewis. Chris is the Vice President of Legal Operations for Superlegal. He is a Utah attorney with 25 years experience in real estate and business law, including construction litigation and construction contract negotiations, representing general contractors, specialty contractors, and more. He has engaged in litigation to enforce construction contracts, surety bonds, and secured and unsecured liens. Welcome, Chris.
Thank you. Appreciate it. It's a pleasure to be here. We're going to be talking about black swans, and I think it'll be very appropriate to some of the stuff you see. So I'm hoping that we can have a good presentation and that people feel free to interrupt with questions or just send the questions at the end during the Q&A session. This is me, I was already introduced, so we won't look at me. When we talk about contract review, excuse me, I have a little cough today. We see a lot of different pain points that people bring up, and I'm guessing that the things that cause you the most pain are on this list. So some people complain of delays. It's a time-consuming process. There's a lot of back and forth. The contracts tends to slow down the work that you want to do. There's the stress, the risk exposure that causes you to lose sleep at night. These are all things that people feel in the contract review process, and I would just say that's normal. And we're going to hopefully address some of the ways that you can minimize those things. So first of all, what is a black swan? It's interesting, the term goes back to ancient Rome originally, back when they thought that black swans didn't exist until people realized that they had some in Australia. But the idea is that a black swan is an inconceivable thing. It's something that doesn't exist. It was popularized by Nassim Taleb in his 2007 book, The Black Swan, but it refers to any event that is extremely improbable and unpredictable, but also has high impact. So the unexpected. So when we talk about black swan events, we're talking about things that are not typical in a contract, that may come up as you perform under the contract, and how you navigate those things. So the reason why we're discussing this is because of a couple recent examples of black swan events. COVID-19 presented us with a unique challenge. I suppose it wasn't unique in the sense that they'd had the Spanish flu pandemic and other things in the past, but as you'll hear in a moment, those things did not have a deep impact on contractual relationships. And the other recent event is tariffs that were imposed at the beginning of the year by President Trump that changed the pricing. If you look, you can see a steep increase in pricing of imported steel or aluminum or other raw materials that came out of those tariffs. Now, we'll talk a bit more about that in a moment, but the important thing to know is that these events have caused a big impact on contracts because they've interfered with the ability of parties to perform their contracts in many cases. So where does this fit into the legal world? Well, we see in the construction world the need to be proactive in considering these things. Let's say that your services involve the supply of steel, as the example was given before, and steel tariffs fluctuated significantly as a result of, or the steel tariffs caused a fluctuation in the pricing that resulted in your inability to perform under your contract or a great increase in the cost of performance. That creates unpredictability. It creates maybe a loss of the contract value and puts you in a significant risk area. So we tend to think of contracts as very standard and predictable, but black swan events show us that unpredictability can be introduced to the contract review process. So I'm going to kick it off by starting about force majeure. That is a contract clause. I think many of us are aware of that. Some may not be, so I'll explain. A force majeure clause is a clause that creates interference in the ability of a party to perform. So force majeure comes from the French. It means major strength or a superseding event, superseding something that came in and interfered with your ability to perform under a contract. And traditionally, it has a few categories. One is acts of God, which is earthquakes, floods, tornadoes, hurricanes, and the like, events that are not directly caused by people. So traditionally, contracts talked about acts of God as an exclusion from a performance obligation. In other words, if an earthquake happens and prevents me from being able to perform under the contract, then I'm excused, or my performance may be delayed to accommodate that since it wasn't in my control. And that has expanded over the years to acts of war or terrorism, to government actions such as tariffs like we discussed, or changing laws, embargoes, labor disputes, disease, including pandemics and epidemics, and other types of unforeseen events. And depending on the clause, it can result in a termination of the contract entirely, or just the ability to delay or modify the terms of the contract. So COVID-19 taught us a few things. One thing that it taught us, and I'll go more into other things in a moment, but one thing it taught us is that courts really want to strictly construe the contract to limit the application of certain events. So we saw in a lot of court cases that COVID-19 didn't qualify as a force majeure event unless disease, pandemics, or government action were explicitly mentioned, since COVID-19 involved all three. If those weren't mentioned, COVID-19, non-performance due to COVID-19 didn't qualify under a lot of contracts. Another thing that we learned is that catch-alls aren't necessarily catch-alls. So often in a force majeure clause, it will end with, after the list of unforeseen events, it will mention other events beyond the control of a party as a catch-all to come up with things that are truly unforeseen. And courts are reluctant to say that that would cover something as specific as, say, COVID-19. So that changed how we approach force majeure a little bit as attorneys. And we learned that wording matters. Does a force majeure clause cause performance to be impossible or impracticable, meaning not impractical, meaning impossible to be put into practice? Or does it hinder? Those are different levels of performance interference, from impossible to merely hindered, and those terms can change the outcome. So if those terms are used in the force majeure clause, that can affect your ability to exercise the force majeure clause. So for example, if it says that any event that is impossible, where it's impossible to perform, may result in a termination or a delay, that is a much more difficult standard than merely being hindered. So that the language of the clause itself is important to its interpretation. In practice, force majeure is, we've seen that first of all, causation is critical. So picture that you are in the pandemic and your local community has been shut down and you're not supposed to go out except for necessary purposes. You're limited to being indoors and people can't work, can't interact, and they are quarantined, as happened in my community. Well, you can see that certain forms of work are restricted in that case. Others aren't. So let's say that you have a web-based business and you can sit in your apartment or home during COVID-19 and continue to get online and continue to provide your services. That's very different from what we usually see in your industries. Design professionals may be more able to do their work at a computer or at a table, whereas people who are doing actual installation or manufacturing or supply might not be able to perform in a COVID-19 type scenario. So the person who is not directly impacted by COVID-19, who can continue to perform, probably cannot claim force majeure for a pandemic. Whereas somebody whose business is entirely upended because personnel aren't able to come to work or there are other restrictions on work may very well be able to claim it. So the causal link is important. Being directly caused is an important element of force majeure. Indirect causes of non-performance are less likely to get favorable treatment in court. In other words, you're less likely to be able to get away with claiming that you can't perform if it's not directly related to the cause. Another element is foreseeability. Some courts heavily emphasize that in order for you to claim force majeure, that you can't perform, the event that happened must be unforeseeable. Some courts reject that. So it really depends what jurisdiction you're in and the evolution of the law as well. But courts really differ on how they do that. And the best bet is to draft clauses to focus on events outside party control and to specifically enumerate events that you think are unforeseen. Now you've got a paradox there, I think you see. How do you foresee the unforeseeable? How do you expect the unexpected? The answer is you do your best. But the one thing that is very clear is that now that we know of things like pandemics being so disruptive, you better list them if you want to claim them. So lessons learned from COVID-19 is that force majeure clauses went from a formality to an essential tool. And I had a slide here. Let me just check if I missed it. Nope, it's probably coming. Prior to COVID-19, there were way fewer cases than once COVID-19 hit where force majeure was a significant part of the case. And so they became much more important. And that requires careful drafting, careful negotiation, careful consideration. So I'm going to try to find I'll probably get to the slide later, but we'll discuss that some more. I'd also like to talk about tariffs and trade policy shifts. These, I mentioned earlier about the tariffs that were imposed earlier this year, and they hit the construction industry hard. Not everybody the same, but most of the people I've talked to were affected either directly or indirectly by tariffs, either through a supply chain or direct pricing concerns. So protective tariffs can add to the volatility of pricing and supply. Pricing is already very volatile in international markets for raw materials or other materials for that matter, and the tariffs increased it. We saw a significant change in February of this year that made that significant. And I will say that prior to this year, I can't remember if I ever saw tariffs mentioned in a force majeure clause. But now you're seeing them more and more. So here are some of the impacts on construction. One is materials costs soaring. So iron costs spiked 9% in residential construction in February. Supply chain disruptions, materials being delayed, increased labor costs. We heard about Long Beach, California, which is a major international port, being full of ships filled with shipping containers, covered with shipping containers that were not offloaded for quite a while. So we see those types of disruptions. It poses particular challenge to fixed priced contracts because you're basing your bid probably on an assumption about your own pricing, right? And when the prices go through the roof, you as a supplier or a subcontractor or whatever your role is might just have lost all of your profitability by absorbing those unanticipated costs. And so these are things that aren't often considered when especially a shorter term contract is entered into. But right now, I think what I'm telling you is you ought to consider planning for these events and seeing how your contract can address them. One way that you can address those is through price escalation clauses. So that allows you to modify the contract rather than terminate it when, say, there's a tariff-related cost increase. And you can have a material-specific trigger, such as iron, aluminum, steel, some specific thing that is mentioned in the contract. And I was asked recently, are tariffs covered by traditional force majeure events that have been in force majeure clauses for some time? And the answer is possibly. Government action, tariff is probably a government action, but you can see how government action is a very broad category and a tariff is a particular type of government action. Some force majeure clauses mention supply chain disruptions, not a ton, but some, and I'd recommend having that in there. Is an increase in tariff a supply chain disruption? Well, it causes one, right? Possibly, or influences one. But what if it just makes your price higher? What if it only increases costs? Is that really a disruption? Or is that a pricing problem only? So while those events are relevant to tariffs, I'm not confident a judge is going to look at a tariff as a government action or supply chain disruption without mentioning it specifically. Hopefully they would, but it's not clear. So we've heard a lot about the political issues surrounding tariffs and economic issues, but these are also contract risks that ought to be considered as you enter into a contract and bid on contracts. This is a slide I was thinking of earlier, but here it is. So we're going to talk about pandemics and global health crises. So in the 10-year span, based on what I was able to find, there were 500 federal cases that raised force majeure to excuse contract performance. So about 50 a year, so about one a week. None of those cases that I could find dealt with pandemics or national health crises. That's before COVID-19. When COVID-19 hit, hundreds of new cases emerged very quickly. And all of a sudden, we're talking about force majeure cases. So perhaps as many as we had seen in 10 years previously. And those cases often were discussing COVID-19, pandemics, diseases, epidemics, health crises, but I don't know the number, but a lot of those clauses did not contain any force majeure event like pandemic, epidemic, or health crisis. And a lot of those cases, the majority of those courts said it wasn't enough to have that catch-all that we talked about. Any other event out of our control was not enough to find protection for COVID-19. Now think about that. Think about how disruptive COVID-19 was, how many businesses were significantly impacted, and picture how on the supply side, on the service side, there was an incredible impact on performance, and yet a court is saying that's too bad, that's your problem. So that is devastating for some businesses, but that is the learning, is you need to consider that in your contracts. So post-COVID, we look at, and you'll see it all the time now, I'm sure you've seen it if you deal with contracts, epidemics, pandemics, quarantine, public health emergency, things like that are now common. And you can see in this example here, it mentions including the COVID-19 pandemic specifically. So we saw more contracts specifically referencing that pandemic. So terminology matters. Epidemic is a regional illness around an epicenter, around a locale. It's not global. A pandemic, the word pan meaning across or through, is spread globally. And you probably want to have both in order to cover different events. So picture that you rely on a raw material from Turkey, and it's being shipped to the US, and they have an epidemic there. Doesn't affect us, but they have a breakout, and they're dealing with that breakout, and it causes workers to get ill, and those workers stop working. Now your supply chain has been disrupted. Now you're at risk of being in breach of a contract because of an epidemic on the other side of the world. So that is devastating, potentially devastating to a business. COVID-19 exposed how unprepared most contracts were. And what we learn is clear, specific language is an absolute essential for not just health crises, but for other force majeure events. I'm now going to shift and talk about cyber attacks and data breaches. We've got it labeled here as the hidden force majeure risk, because this is not something that is traditionally mentioned in any force majeure clauses. When I started practice as an attorney 26 years ago, I don't remember ever seeing cyber attacks or data breaches mentioned in force majeure. So a little history. I found it interesting in preparing for this to see that the first cyber attack could be construed as taking place in 1834 in France, involving the telegraph system. So market information was stolen from that to give somebody a market advantage. But cute historical facts aside, real cyber attacks and data breaches became a bigger issue when the internet became prevalent and appeared in everybody's home and business in the 90s. So by the 2000s, almost everybody was familiar with different types of cyber attacks and data breaches. So it's obvious, right? The right way to avoid cyber attacks is to avoid technology. We've got this meme here, can't fall for phishing scams if you don't check your email. Genius approach, right? Go hide in a cave and you will have no risks. That's probably true about any risk, except getting very cold. But the point is you can't bury yourself under a rock. You can't hide from these types of problems. We live in a technology world. All of you are connected to technology right now. And when there's technology and when there's the ability to connect to something remotely, there's the opportunity for a breach. Cybercrime is now a $1.5 trillion industry. It's the #1 global business risk. The average cost of a data breach is now $4.5 million. 82% of breaches involve the cloud, which is something that 20 years ago we didn't really even think about, right? People had designated servers and now people store information on the cloud. If you can access the cloud, a remote storage system, then in theory, a cyber criminal can access it too with the right skill set or the right passwords. Phishing is a big issue these days where you are lured into thinking a link in an email is safe and it's not. Ransomware is making up about 1/4 of cyber attacks, where somebody says they steal your files, your information, or lock them out, and then offer to give you access for a big fee. So these are on the rise. These are real current event issues. Are you covered? And there's one way to find out. Look at your most recent contracts. Look in the force majeure section, most likely place to find it, and see if you have cyber attacks on critical systems, internet infrastructure failures, things like that mentioned. So do traditional force majeure clauses help? Well, traditionally they mention acts of God, maybe theft or malicious damage. An act of God is out of your control, but I wouldn't say that God is a cyber criminal. So theft is, I would say that cyber attack can be perhaps theft, but then you're left arguing it to a judge. Your Honor, this is theft. It's a cyber attack. And the judge could say, doesn't theft traditionally mean something different? The loss of tangible goods, isn't this a little bit different from that? Why, if you meant cyber attacks, why didn't you mention them? Or why didn't you mention theft of data or data breaches? So you can see where if you're arguing it to a judge, you've already missed an opportunity to save a lot of money and stress and delay, not to mention the risk of the judge just not agreeing with you. The other one, malicious damage. A cyber attack could be malicious damage, but what if, I mean, that sounds a lot like vandalism, but what if the malicious damage was not particularly malicious? Maybe it was an accident, an accidental breach. And what if the damage wasn't to any property, but is more damage to reputation or damage to somebody accessing private information, that's a bit more intangible than what a judge might interpret malicious damage to be. So traditional contract references may not be adequate to protect you in the case of cyber attacks in a force majeure situation. So there are some issues I'd like to discuss. One is performance versus delay. So is force majeure only triggered when performance is impossible? Or like we discussed earlier, are there other situations can trigger it? Does it apply to delayed performance? What happens if there's a system outage that lasts a day? How does that affect your operation? How does that affect the impossibility of your performance? Is that a critical day? Do you have a time is of the essence clause that says any delay is default under the contract? Those are all questions you need to consider and do some contingency planning for that eventuality. Then exclusions for war and terrorism. These are hard things to define. I remember growing up and hearing about the Vietnam War and how it was called a police action. So we'll talk about that more in a moment, but do war and terrorism cover cyber attacks? So if your force majeure clause mentions war, mentions terrorism, does a cyber attack get covered? And I would say perhaps if it's linked to a state action, a foreign government action. But you can see the problem, I think, is that cyber attacks are not usually associated with war and terrorism because they're commonplace, but they certainly are associated with war and terrorism. And I would say there's probably no modern war where there isn't some cyber attack happening. Sometimes, though, from non-state actors. So we saw, for example, with the Russian invasion of Ukraine, is that a bunch of hackers worldwide on behalf of Ukraine or because they sympathized with Ukraine, attacked some vulnerabilities in Russian systems, both government and non-government computer networks. And is that enough to be a state action? Did Ukraine order it and request it? That would be very difficult to prove. But hacker groups may have loose or unclear ties to governments or ideological movements. And as such, a war or terrorism reference in a force majeure clause may not cover a cyber attack. I would not expect it to do very well, especially these days where cyber attacks are well known as being their own thing. So as I just mentioned, the burden of proof lies on you. To claim force majeure, you have to prove that the requirement is met. So to claim it due to a cyber attack, you'd have to prove who carried out the attack, and for it to fall under war or terrorism, and that the attacker is sufficiently linked to that state. But generally, if you're going to prove a cyber attack or data breach, you've got to have the facts. And it's best to have a force majeure clause to explicitly address these types of cyber risks. Let's talk about climate-related disruptions. So we talked about acts of God, and it's defined traditionally as an overwhelming, unpreventable event caused exclusively by forces of nature. And it traditionally includes earthquakes, floods, tornadoes. Now it's often broadened to include all exceptional natural events, such as tsunamis and hurricanes and major storms and outages and things like that. But we now have a lot of scientific opinion that global warming is caused by acts of man. So that's a heavily politicized issue right now, I'm mindful, but the anthropogenic, the origin of climate change due to the behavior of people, all of a sudden calls into question whether that's an act of God. I just throw that out there. I'm not aware of any court treating that, but it's something to consider. So extreme weather events, depending on the sources you look at, there may not be an increase in frequency, but there's certainly an increase in severity. And many sources believe an increase in frequency in extreme weather events. Certainly if they're getting more severe, then the number that are severe is increasing. And those weather events can disrupt supply chains, job sites, energy and water uses, other natural resource usage. So extreme events can cause great chaos. And governments and agencies of governments try to address these things through legislation, through regulation, through international treaty. So you can have water restrictions, energy caps, construction halts that might be related to the Clean Air Act, Clean Water Act, the Kyoto Protocol, Paris Agreement. These things can have an impact on what constitutes force majeure possibly, but more directly what constitutes an extreme weather event and how you can behave in light of limitations caused by severe weather. So I would say we should expect more government interventions tied to climate policy. That's been the trend over time. So that's one lesson. Another is force majeure clauses should clearly address environmental regulation changes. What if something that you're doing now later becomes regulated, either through a greater cost or through a prohibition? Climate-related natural disasters that might emerge. I mean, you can have, just to wax wild in my imagination, imagine that the heating of oceans causes algae to flourish, which causes death to a lot of marine wildlife, which causes restaurants to not be able to serve as much seafood, which causes an impact on the construction industry. You know, you can imagine what changing world climate events may do to affect billions of people. It's not hard to imagine. And it sounds fanciful, right? What I just came up with. But I would say the lesson of this is what's foolish today is wisdom tomorrow. What seems like panic mongering and over planning today becomes what saves your bacon in the future. We've seen that with COVID-19. That's one of the lessons here. So planning for unlikely eventualities is what the Black Swan presentation is all about. So let's talk about other events. So what about sudden insolvency? How do you protect against your subcontractor or your supplier or your general, somebody going insolvent? How does that affect you? Well, the first thing you can do to plan around that, by the way, is to do due diligence, is to look into your counterparties and see who you're dealing with and see whether they are able to meet their obligations. And second, to look at your own ability to weather a storm. So do you have contingent plans? Do you have the ability to back up and create a new supply chain if one is disrupted? But in this case, we're talking about insolvency of a counterparty. Have you audited them? Do you have an audit right in your contract? Realize that once somebody files a petition with a bankruptcy court, your contract might even have limited ability to affect what happens. So bankruptcy court can trump what's happening in a traditional court. So I've can personally attest, I've been in court where I had a judge say to me, well, Mr. Lewis, you have a bankruptcy proceeding that's begun in another court, in the bankruptcy court. Can we proceed, or do we need to cease right now? And that judge was very concerned about the performance of her duties as a judge in that case without seeing what happened in bankruptcy court, because the contracts involved in our case were suddenly limited by bankruptcy rights and bankruptcy laws. So insolvency of a counterparty can be extremely disruptive. It can, at the very least, cause delays. If you're the one who's impacted more directly, you might have to suspend or terminate the contract. And there's going to be a continuity of services issue. If you're getting them from a sub, that may impact your ability to perform. So, like I said, pre-contract due diligence is critical. I would say that's your first line of defense. Know who you're dealing with and their ability to perform, and what happens if they can't. Is it, for example, a sub where you can easily replace them? Or is it a sub where you depend entirely upon them? That may make a difference. I would also say contingency planning is the first step. Next is strong contract language, your ability to suspend or terminate your performance, your services, your work, and defining clear effects of termination. And then if you have audit rights, then regularly evaluate the financial health of the people you're dealing with. If you don't have audit rights, still attempt it. Maybe write audit rights into your contracts, but you should be on top of things. You should also encourage good open dialogue and make sure that you can get them to reach out. So if there's a notice obligation, if they can't perform, that you would have that in the contract. Next is war as a black swan event. So I mentioned the Russian invasion of Ukraine. On some level, I had neighbors. I had a neighbor where the husband was Ukrainian when that happened, and his wife was ethnically Russian from Ukraine, from right in the Donbass region. And they had kids, they lived in my neighborhood, and I talked to them about this event, and it was, to them, deeply personally disruptive. They had family there, they did a fundraiser to bring people to the States. But I can say that the invasion has far greater reach than affecting locals and those who know them. There was disruption to oil and gas, to agriculture, oil and gas heavily in Russia, agriculture heavily in Russia and Ukraine, international sanctions, US companies pulled out of Russia in droves, resulting in billions of dollars of economic loss. So it's not what buildings get shot and who gets hurt in war that is the only impact. There are also significant economic and supply chain impacts. So in your contracts, you might see interruptions, so sanctions involving counterparties or subcontractors or suppliers. You might see sanctions, trade bans, export controls. Operationally, you can picture a site being closed, project being halted. If your sites are shut down, you're going to have a negative impact. And labor shortages, and employees being unavailable because they've been mobilized, called up in armed conflict. Or merely they can't work because they're working to survive. So we're winding down here. I will try to speed up a little bit so that we have plenty of time for questions. So just realize that the word war has been heavily politicized over many years. I talked about how the Vietnam War was also called a police action. What constitutes war? Is it when a government body is formally declared war? Does it include armed conflicts? Does it include something else? Make sure your contract isn't too narrow and isn't lacking the right idea to protect you. You can also look at price adjustment clauses, price escalation clauses, material adverse changes or material adverse effects. That's usually in mergers and acquisitions, but things that look out and protect you in the contract. So quick conclusion. First of all, it's worth brainstorming what event could come next and listing them specifically in the contract. Courts now expect pandemics to be explicitly listed in order to get that protection. And we could have another pandemic, just like we had the last one. You probably want to clarify what constitutes non-performance, whether it's temporary or requires a termination of the contract. Usually one party is not as affected. One party has a payment obligation while the other party has a performance obligation. It might not impact both parties equally. Causality, we talked about this. What is the link between the event and your inability to perform? Judges may look at that very closely. I expect them to. What happens to in-progress work? What if you can't easily stop the work? What if you have to demobilize and it's very expensive and you're not sure whether to? What about getting paid for work that's partially completed? And at what point is that your risk versus the other side's risk? What becomes the effective date? When, how quickly can you claim it? What notice requirements might be there to give the other side? I can't perform anymore. What duties to mitigate are. So mitigation is an implicit legal obligation where so whether it's in the contract or not, in other words, you have to try to minimize harm. So let's say you've got a leak at a site in the basement and it's causing a big flood and is damaging all your finish work. It's probably not enough to stare at it. You might need to try to turn it off. You might need to just call the owner. You can't be passive. We have to mitigate damages, try to limit harm. And so those obligations can be implicated. Here it says well-drafted contracts are your first line of defense. I would reiterate what I said before, that due diligence and contingency planning is your first line of defense, but a strong contract is important. And I think, just think about supply chain disruptions, business continuity planning, think about backups, things that you can do so that you're not arguing force majeure in court. And I would just say, maybe as a final note before I open it to questions, consider reaching out to the other side when you have an issue emerging, and open discussion, and try to be open, not intransigent, not stubborn, but try to just work with the other party. You'd be surprised at how often they understand and are willing to work with you, even though horror stories about owners or generals or subs above you might get more press that they're not willing to help. Many are. So open channels of communication. I'm going to skip through these last couple slides, not very important, but I'll open it to questions and answers. Do we have any questions from the group?
Thank you, Chris. Just a reminder to attendees, we're still taking questions, so if you'd like to submit, please do so now. First question, with everything happening, would ICE raids be considered a force majeure event?
That's a great question. So we've seen ICE raids with crackdowns on immigration policy that have made the news a lot right now. Would they be a force majeure event? Well, if your contract specifically mentions immigration enforcement events that affect manpower, then I think. If not, and I've never seen that in a force majeure clause, you could say government actions could be perhaps implicated there. So you might be able to claim that's a government action. You might also be able to claim that there's a workforce disruption, although traditionally that often implies strikes or things like that, or lockouts. But it's a great question. It's something you ought to think carefully about if that's a risk for your company, because those things are things that are happening now that a year ago we didn't expect. So that's a real black swan event. Other questions?
Next question, do force majeure clauses cover direct and indirect causes equally?
Yeah, we talked about that a little bit. No, not equally, but I need to clarify that. So usually direct effects would be covered. And I gave the example of somebody sitting in the pandemic and COVID-19 and working at their computer and not really directly affected by COVID, they probably can't claim it. But the more you get toward disruption to what you're doing, the more you're likely to claim it, but realize that the result is binary. A court's either going to say, yes, this falls in that category and constitutes acceptable force majeure event and constitutes acceptable non-performance, or it won't. So it's kind of like a pool that's 8 feet deep. It's over your head. You can drown in it, right? It might as well be a mile deep. It doesn't matter at that point so much. And so you want to be on the safe side. So it's best to really look for direct causal links before you claim it.
Okay. What about domestic terrorism? Is that covered by standard force majeure clause?
Yeah, that's a great question. And that's an interesting one because we see the word terrorism using politically now. 2 weeks ago, 3 weeks ago, we heard about an alleged shipment of drugs from Venezuela being fired upon by the US off the coast of Venezuela in international waters. And the justification that the government presented was this is an act of terrorism against the United States because drugs are awful and they addict and enslave and bankrupt and people die in the trafficking and other things like that. And so that's maybe not traditionally what we think of as terrorism. We think of terrorism as bombing a group, trying to instill fear in people, usually very targeted to a particular group that the terrorist is not pleased with. And that's what we think of as terrorism. But you see the term politicized. So could domestic terrorism be included? Perhaps, but it would know that a lot of terrorism is usually assumed to be with a foreign actor involved and under the auspice of a foreign government. And so you might have trouble claiming that. So you might want to just list domestic terrorism or things like it and come up with a few similarities. That's another great question.
Well, thank you, Chris. That concludes the Q&A portion. Thank you for that informative webinar. Thank you to Super Legal for sponsoring this webinar, and thank you to our attendees. We'll see you next time. Have a good one.
Thank you all.
Bye-bye.